How's everyone doing today on Friday afternoon? Well, the Owens had their bankruptcy chapter 11 this time dismissed, which might sound like it's a win for them, but they're actually pretty screwed. Something I have not seen people talk about is the fact that, am I even in the right stream here? Yeah. Is the fact that there's going to be some implications from the IRS based on a couple different things. So we're going to listen to the hearing. Then we're going to talk about, at the end, just a little bit of the accounting stuff. If this is your first time here, we have playlists in the description of this video for all the different subjects we cover, such as Lauren Armstrong, Sarah Boone, Diane Downs, Laura Owens, all the crazies. They're all morons. And hello to the replay crew, and hello to everyone who's live with us in the chat. All right, let's go. Okay, I realized why I was confused. I have two different studios set up, and I fortunately clicked live on the right one. Suma should be here any moment, but let me say first, she should be here. For those who didn't see it, it was pretty uneventful or haven't seen it yet. It's cut down. I got it down to like 15 minutes. I got it at 130% speed. But here she is. I know her as summaloudmouth, or you know her as summaloudmouth. I know her as the second gunman on the grassy knoll. So, summaloudmouth. How are you?
I'm good. How are you?
Good. And your sound sounds good, at least to me. Chat.
Yeah, good.
Is she loud enough? No echo for me. So I think we're rocking.
All right. Did I tell you I took the coom out of my channel name because I was,
yeah.
You know.
But it's habit, right? So
yeah, no, you said it right.
Okay.
I'm basically telling everyone else just so that, because a few people were like, I was looking for your channel, I couldn't find it, and I was like, well, I took the coom out. Hi guys.
So it's like such a Lauren statement.
It's a very embarrassing situation. Not for me, obviously.
Obviously not for you. All right, let's see. Which one is this? That's not it. Problem is I set this all up in the other stream, in the Lauren one. Oh. You know how close that would have been a disaster. I almost hit live on the Lauren one. That would have been terrible. Let's see. Need the right banner, but let's just get this going.
Let's go ahead and get started. We've got two matters on calendar. This is the time set for continued Chapter 11 status conference, as well as a hearing on the debtor's motion to dismiss this voluntary Chapter 11 case. I'm aware of the parties' filings, but let me turn it over to you to see how we wish to proceed. Shall I start with you, Ms. Jamo?
Thank you, Your Honor. Yes, so just to remind Your Honor, the debtors had filed a motion to dismiss, and at the...
There's a slight echo for some reason. I don't know why. Whatever.
Nico wants the Two Blonde Crew intro.
Oh. Yes, of course. How could I have missed it? I don't know if anyone else hears the echo. Hopefully it's not annoying if you hear it. I don't know.
Last hearing at which that was raised, Your Honor wisely pointed out that we needed to collect some documents and do more investigating before the case should be dismissed. I'm very glad that Your Honor had required that. We did receive what was called an accounting of the GoFundMe funds, and we received many bank statements that I was able to review. As the U.S. trustee laid out in her recent supplemental response to the motion to dismiss, there was some disturbing material that came out through our investigation. And for that reason, the U.S. trustee's position is that there's definitely bad faith here and the case should be either converted or dismissed. And also, as laid out in our supplemental response, we think that based on our analysis of the assets, that dismissal with a 2-year bar to refiling would be the wiser choice, because there does not appear to be really any sure collectible assets in this case.
Flora said there's more bankruptcy issues. I thought it was finished. Well, yeah, this bankruptcy is finished. It was dismissed. They were
too poor to have bankruptcy issues.
Too broke. I'm not talking about the bankruptcy specifically not being over. I'm talking about their problems, because I think the consensus that I've read online is everyone's like, oh, well, they're, you know, they're gonna get off again or whatever because they don't have anything, so people can't collect anything because their income is exempt from garnishment. But that's not 100% the case. Lynette P150. I don't even know who this broke heifer is. Assume it's not broke.
Hilarious.
Sick
burn.
Right. Thank you. I did have an opportunity to review your supplemental response to docket number 89. Tell me more about why the recommendation is for a 2-year bar to refiling. Often we use a shorter period if there's a secured creditor looking to foreclose, or a longer period if we're looking for litigation to conclude. 2 years is pretty lengthy, so could you give me some additional information about that long period? And also, it's my understanding that Ms. Naylor and Mr. Owens have agreed to that period. Is that correct?
Yes, Your Honor. Yes, I should have pointed that out. Yes. Ms. Naylor and Mr. Owens, in correspondence with me, have indicated that they were willing to have the case dismissed with a 2-year bar to refiling.
I guess I'll first say, I don't believe they're going to hold to this necessarily. I would not be shocked if within the next year we see them filing a Chapter 7.
Yeah, I mean, you can't. These people are they're wild animals, you know.
And they're going to say, "Oh, I didn't understand. It was."
Yeah, they say and do whatever they want. That's why they're going to have to ultimately be locked up, or you know.
Mm-hmm.
Ed McMahon over here is going to be the lone ranger, the only one left.
The reason that we're asking for 2 years is because this case was filed in bad faith, we need to have a sufficient deterrent to prevent another repeat filing that would, again, interrupt creditors from pursuing their rights. 2 years, just weighing it seems like an adequate amount of time to allow a foreclosure of the home to follow through if that's what's going to happen. I understand that there was a foreclosure set first in May, then I think it was reset to September. Now I believe it's reset to November. Ms. Naylor would know that information better. I don't know what is going on with that process, but it seems to me that that is the driving force behind these bankruptcies is the house, right? So I think that we absolutely need to give the creditor sufficient time to foreclose on the house if that's what's going to happen. I think 1 year might not necessarily do it, especially if they're trying to work something out. And so,
I can't explain them.
Well, one is 11, the other one is, you know.
Yeah, so one's 7, one's 11, one's 13. Chapter 7, I think everything gets a clean slate. I think maybe 11 and 13 are structured. 13, I know 13 is definitely structured, so it's not like a clean slate. They put you in like a payment plan, basically. I think maybe that's true. I don't know. Whatever.
I feel like it's actually to the benefit of the debtors to have it be 2 years. So,
wait, did you just say it would be to the benefit of the debtors to be 2 years?
Well, yeah, because maybe
I do like this part. The judge is like, "Wait, what? How is this beneficial to them?" And then she'll follow it up like, "Have you ever seen it be beneficial?" She's like, "Well, no, I've never seen it actually benefit the debtors."
The judge wasn't going to be paying attention.
This Forever Wander. I'm dumb. Does dismissing with prejudice mean no? You can't just declare bankruptcy and get out of this. Like it's bad for the Owens. Yeah, this is bad for the Owens. And with prejudice means they can't file any type of bankruptcy for 2 years.
Oh, interesting thing.
But I don't know that they're going to stick to it. Okay, yeah. 13 is paying back, 7 white slate clean, 11 is for business.
that gives maybe because if there's that much leeway given to the mortgagee to foreclose on the property, maybe they'll be a little bit more willing to spend some time trying to work something out with it.
Oh, I see. So should the mortgage company have additional time during which Ms. Naylor and Mr. Owens cannot file bankruptcy, they may be willing to enter into negotiations during that elongated period.
Right. Exactly.
I understand. Thank you.
So there's that. And also there were 2 lawsuits against the debtors that those can proceed. And I think that based on the information that we discovered and laid out in our supplemental response, there are potential claims, I believe, by GoFundMe Inc. or donors. We definitely need to make sure that there's sufficient amount of time to allow those parties to pursue any rights if they choose. I mean, I have no involvement in that, but just based on my own investigation. So I think 2 years gives an adequate amount of time and is proportionate to the bad faith that we've seen here, and it gives an adequate amount of time to allow creditors to pursue their rights in state court, which is really what we want, right? That's the best interest of the creditors. And yet it doesn't completely foreclose the debtors from refiling should the need arise later, but there's a sufficient buffer with a 2-year bar so that creditors won't be harmed yet again.
So layman's terms, by no longer being a bankruptcy, now everyone can sue them, right? And the bank can reclaim the house if they choose to. They have no protections from bankruptcy, which is why they kept filing it to stop foreclosure procedures. Now they're saying, "Oh yeah, we're working with the mortgage company or whatever." But don't they have like 500 or no, I'm trying to remember the numbers. So it was 500,000 and then 700,000 in unsecured debt. So here's the deal. That cannot be garnished against their pension and their Social Security because those are exempt. However, because if they were to declare bankruptcy in Chapter 7, the slate is wiped clean and they don't get any, what is it called? Cancellation of debt income imputed to them. Do you know what I'm talking about, Suma?
I'm not listening to you.
Oh, okay. So normally, if you're not in bankruptcy and you, like for instance, I had a loan on my 401k at the old company I worked at, right? And when I left and didn't repay the remaining, it was like $2,000 or something, like that was left on it. I didn't pay that off, and then so eventually they canceled it, right? And then I had $2,000 of income that I had to report as cancellation of debt and COD income.
It doesn't accrue interest if you don't pay it?
No, it was for a new home. So, I mean, like, it was like the last sliver. I just didn't pay it. And, but anything, like if you have a credit card and then the company writes it off because you're not paying it, you will get a form, cancellation of debt income. And so you have to pay tax on that.
I see.
Because it's the same thing as if you were paid the money. It is, but it doesn't always happen when they take you to court and you get sued. But long story short, so I think they're thinking, oh, well, they can't touch our income and we'll be able to, refinance the house somehow or whatever they're thinking there. I don't see that going well. But people are kind of pissed because they're like, well, they still get their $21,000 in income and they're not going to be able to be collected against. That's not true. Because what happens when their unsecured debt gets canceled, that's going to be reported as cancellation of debt income, which can be taxed in some. Well, there's another caveat, and they have to pay that tax. Their pension and Social Security income might be exempt from income tax, but they cannot ignore the tax bill from a cancellation of debt income. Now, the catch is, in order to the IRS has a test. Basically, it's a snapshot of liabilities versus assets. So first, they basically, whenever the debt is canceled, okay, on that day, how much in liabilities did you have? How much in assets did you have? And that might sound like, oh, well, they're never going to have any assets. So like, for instance, if they had $100 in the bank account, and they owe $2 million, well, they would take that $100 off of the $2 million. And the $100 is the only amount that can be imputed from that cancellation of that debt. Right? So if they just spend on everything, then in theory, they wouldn't have any assets to measure against. But if they lose the house, that $2 million goes away. So then let's say we're left with $700,000 in unsecured debt. Ron's pension has an asset value in some cases. So it depends. If it's a defined benefit, if there's certain conditions, defined benefit, survivor benefits, cost of living adjustments, and if there's a lump sum payout option. No joke, Kate, hold on. This is how they can be screwed. Let me show you. We're getting to it.
Okay. Some people like to hear this explained.
People, like, if you want to know how they can get screwed, this is how, because I don't guarantee they're not thinking of it. And there's nothing really they can do to avoid it.
They don't know this.
There's nothing they can do to avoid it.
Yeah, and also they don't care. They're just two young, crazy kids,
What you do is you take his defined benefit, I think somebody said it was $14,000, right? And you plugs into an actuarial table at his age and saying, okay, well, how much longer do we expect him to live? And, it doesn't really take Parkinson's into account or his health issues. It's all an actuarial table. So I did this. And I came up with a figure at $14,000, assuming no cost of living adjustments, no survivor benefits, and no lump sum payment. just the 14,000 comes out to roughly 1.1 million as a current fair market value for his pension. So in the case of a cancellation of debt snapshot, it would be your assets and your liabilities at that point. So if you have a $1.1 million asset in your pension and you subtract out your $700,000 in liabilities, unsecured debt, well, you have $400,000 worth of available assets, sir. So when they take you to court, sue you, you don't pay, you get taxed on it. The IRS is going to say, okay, that's $400,000 worth of income. You got to pay us the tax, and you can go to prison for that.
They can't take that income, though? They can't take that?
No, they can't. They don't take the income. It's just for the calculation of the snapshot itself to say, are there assets that could be collected against in theory, right? Because the pension is not exempt. So that is a huge problem for them, which I guarantee. Now, one more twist, and then we'll get back to the video. A tax court has already ruled that in scenario, it is not considered an asset for the cancellation of debt. The IRS disagrees, and they're like, no, we're still considering it for everyone else, even though this guy won his little case here. But if there's a lump sum payout amount, if there's cost of living adjustments, or any survivor benefit transfers, it makes it very likely that it would be considered as part of the cancellation of debt snapshot. All right, that's it.
Okay. Wake up, everyone.
Did you follow? Did you follow along at all? Yeah.
I did. It doesn't matter if I follow. You have a whole bunch of people here. Why are you always asking me?
Because you like the litmus test. The litmus test. I'm like, well, Suma gets it then.
He's the stupidest. So let's think of how everyone else is going to understand that.
All right, Suma got it? All right, got it. Yeah, and there's no getting rid of tax debt. You can't declare bankruptcy on tax debt. Sorry.
I mean, if you could, everyone would do it.
Okay. Thank you for explaining that. One reason I had asked is just because there was the pending foreclosure sale. The court previously declined to extend the stay.
Yes.
And so it seems that the mortgage company could move forward. Plus, under Arizona statutes, they could foreclose within 90 days anyway. So it just seemed like a long period. I hadn't really considered the idea that a longer period would actually motivate the mortgage company to engage in negotiations. Have you seen that happen before?
No, but I don't know why the mortgagee is continuing to move out the foreclosure dates on.
There it is. Have you seen that work in the debtor's favor before? No, but
You want now?
But for some reason they keep pushing it out, so I don't know.
Assuming that they're working with them, that's all. I really don't know. I mean, I've tried to reach out to them, and they've not really been very responsive to me, to the banks.
Compass wants you to explain that
that's
again.
just one factor, but I do believe that
good one.
we should have sufficient
I'll have you know there were very few numbers in that explanation, so
time to
I'll be right back. I'm just gonna run out to the bar real quick.
okay.
Creditors, not just the creditors that
the
were listed on
bar.
the schedule, but other potential claimants that I mentioned in our supplemental response to pursue claims against these debtors without a bad faith bankruptcy filing.
Okay. Another area of inquiry, and you did address it in your supplemental response, was just whether conversion would yield any distribution. I read what you wrote, and I certainly appreciate that trustees are loath to have cases where we have animals that need care and food, et cetera. It ends up costing them money as opposed to yielding benefits for creditors. So I certainly...
The TLDR is possibly get. It's not a non-zero, and I'd say it's better than 50%. So.
I understand the reasoning of the U.S. trustee there. Is there anything else you want to tell me, not necessarily specifically with animals, but any of the other assets in the recover, the opportunities for recovery?
Well, Your Honor, I should mention to you that while the case was in a Chapter 13, there was a short time during which these debtors' case overlapped.
They're like
with the filing
85 years
of
old,
a
Dorgan.
Chapter 7 case by the debtor's daughter, Laura Owens, and the attorney representing the Chapter 7 trustee in the Laura Owens case was Terry Dake. And I know that he was very actively looking into potential assets. And if you recall, there are some businesses that are co-owned by the daughter and either Miss Naylor alone or Miss Naylor and Mr. Owens.
Teresa, this isn't C Corp though. This is their own personal unsecured debt, credit cards essentially, right? All that bullshit.
The daughter. And I did reach out to him to ask
their personal debt.
Him what his professional opinion was as to whether the preferences made to the daughters is something that he looked into, and whether there was any assets that he could conceive of, either in the Chapter 13 case or in the Chapter 7. And it was his opinion, just to me, in an informal discussion about it, that this did not seem like a good case for conversion. So we did factor that in. I didn't put it in the pleadings because it wasn't a real formal discussion. It was just something that I had run by him because of his familiarity with the case. But I did agree with his assessment based on my own analysis of all of the assets that are disclosed.
Okay, thank you for that additional information. And I do recall a prior hearing you had mentioned Mr. Dake was involved in this case in some respect. So now I understand it's with the debtor's daughter.
Yes.
Okay.
Yes.
All right. What else do you want to tell me?
Your Honor, I think we just pretty much laid it out there. We think that there's definitely concerns, but in light of the financial situation, conversion would not make sense. It would be really a burden, I think, to any Chapter 7 trustee to ask them to take on such a case. So I do think that dismissal with a 2-year bar is the only way to handle it because of the bad faith. I do think there was a lot of bad faith, and that because of that, that's why we should have a little bit of a longer bar on refiling, because this is one of the worst I've seen in terms of misstatements, misrepresentations, and so I would ask that that's what Your Honor do, especially in light of the fact that the debtors are agreeable to the 2-year bar.
All right. Thank you, Ms. Jamo.
Thank you.
All right. I note that there are a number of individuals who are appearing by Zoom. I'm wondering if there's anyone present who wishes to be heard before I return to Ms. Naylor and Mr. Owens.
Yeah, this is definitely going to affect Laura. I mean, once they lose their house, the only way they can't lose their house is by strapping way down on spending. They're not going to be able to support. She's going to have to get a job. Here's Arizona, Carolina.
All right. Hearing no one speak, I'm going to go ahead and turn to you, Ms. Naylor and Mr. Owens. What do you want to advise the court at this time?
That we have reviewed.
But somebody did say, I saw this comment on Reddit. If she goes to prison, she'll have a place to stay. Take that! Take that, you dumb. So maybe that's why she's dragging her criminal case out.
The trustee's supplemental response, we agree with the final recommendation to dismiss the case with a 2-year bar, but we would like to state respectfully for the record that we dispute any insinuation of any sort of fraudulent intent or bad faith. As pro se debtors, the Chapter 11 reporting rules were very complex for us, and any omissions or anything like that were honest, unintentional mistakes that were due to our lack of counsel, and we feel we cooperated fully and provided any of the bank statements for 18 months, anything that we could to ensure total transparency.
Okay, so tell me about the 2-year bar date refiling. What is your position with respect? It was represented in the record that there was a stipulation and agreement to that period.
We had informal discussions with regard to that, and we had told the trustee that we were willing to go with a 2-year bar. I mean, frankly, we hope we are never, ever, ever in this situation again. And as we had explained before, we are trying to explore what options would be available for us to modify the mortgage and to come to agreements with the other creditors to resolve this outside of bankruptcy.
This is an insane explanation. We hope to never be in this position again. How do you hope to never be in this position again? You before you declared bankruptcy, you got $140,000 from GoFundMe. It's all gone. You haven't changed anything. You haven't sold your house and moved into an apartment. How do you think you're not going to be in this position again? You've gotten even worse. You know what I mean? Like,
Yeah,
this is insane. This is what makes me think.
Not realistic.
This is what makes me think that their game is like, oh, we can file Chapter 7 again.
I'm not sure they have a game, really, but if they do, that would have to be it.
Yeah, well, they're thinking if they get into foreclosure, we'll just file Chapter 7. Look, and then we'll dismiss. Then we'll dismiss. You know,
They have no choice because they don't have the money to pay what they have to pay. They've let this daughter of theirs fuck up their whole life, which is probably kind of fucked up before anyway, financially. I don't know. I mean, they don't seem like they've made sound advice decisions.
Well, they I think they think they're untouchable because it's tax free, or because their current income cannot be garnished. I think they think that they're going to get away without. You know, the only thing they got to do is make sure that the mortgage company lets them keep the house. And then, you know, whatever else, whatever.
Okay. Are you engaging with your mortgage company or others in terms of in an effort to resolve those outstanding claims?
Yes, and we had, well, as far as the mortgage is concerned, we very much appreciated your suggestion that we work through the, I believe it's the MMM program through the bankruptcy court. And when we explored that, it appears that that would only come into play while we were actively in bankruptcy, and that once the case would be dismissed, that entire process would go away. So we have been trying to work through correspondence with the mortgage company, and we have again been told that in response to our latest communication with them, our latest letter with them, with the latest correspondence, that they will respond to us within 30 days. So perhaps that's why they maybe have moved out the foreclosure date more. But we are certainly wanting to work behind, the scenes I guess outside of bankruptcy court with them to resolve this.
Okay. Well, very good. I wish you good luck in that regard.
Thank you, and thank you again for your recommendation on going through the mediation program support. We really wanted to work with that, but it just looks like that ends when the bankruptcy would be dismissed.
This is like Sarah would.
Kouri, what else do you want to tell me?
Think she's receiving a reward or an award or something.
Just that I think regarding the GoFundMe campaign, we wanted to stress that there were no promises that were ever made to the donors, and that this was an effort that was the culmination of my husband's 5 decades on the air, and he and our family were very, very deeply touched by the outpouring of support from his.
I would not have made this statement.
No, me neither. For a lot
Because, yeah, I would say for the main reason of, if anyone is pissed at you about the GoFundMe thing, you are rubbing it in their face, and you are just not shutting your mouth and going away. Because before this, they go, oh, they have no money. Okay, what's the point? I'm going to hire a lawyer. I'm not going to get anything, right? But now you're trying to do, it's such an outpouring because of my husband's 5 decades and the love, and it was so touching. They're pissed.
And like Carolina's saying, also, it's like he worked for 50 years and you had to get a GoFundMe?
Well, to avoid the bankruptcy that they filed immediately afterwards.
Well, why? I mean, this man had a good living for 50 years.
It's stupid. It's a very stupid move, but I don't think she can.
Yeah,
I don't think they're
smart
incapable of hearing themselves.
No. Oh, or they're capable of hearing themselves, but they don't understand what it sounds like to literally everyone else.
It's a pension. It's a defined benefit pension. I assume it's a defined benefit pension, which is different than a 401k. He has interest in a pension.
Listeners who have truly become like an extended family to us over the last decade. So this was an appeal that was needed for housing and food and transportation and those kinds of things, and we were just very, very grateful for.
Well, DoorDash, housing, you didn't pay your mortgage very much, and transportation.
I mean, how do you not reflect at some point? Like,
they have one car, don't they? A Nissan Rogue or something. It's not like they have, or do they? Do they have some kind of specialized van? Ron's not in a wheelchair. He walks with a walker, right? So there's no like lift or anything. It's,
I mean, even if he did, it's not necessary to have that kind of like, and even if it's so, that is usually covered at least in part by insurance, right? Like, I mean, I don't know how these people are more ready. Like Dorgan just said, or Dor just said, the horses should have been sold a long time ago, along with the,
right.
Like, I mean, I have a pile of shit right now that should have come to it. I'll start selling it. Like, it's just how it goes.
Right. Yeah. I mean, yes, exactly. I had the same thing with some of my crypto, right? I didn't want to sell it.
Live my life keeping in mind that I should try to get shit I can sell for a lot of money. Should have come to that. That's all.
They would have been off better buying a boat. A boat is less expensive than a horse, and they've got like 7
they have
of them.
A home, and that's not helping them. So
no, they move on a houseboat.
Should have been buying property equity all along for the last 50 years.
Yeah. All right.
For those contributions.
All right. Thank you. Anything further?
Not for me.
Okay. Mr. Owens, did you say
something? I want to thank you for the award.
Not off the top of my head.
Okay. All right. Thank you. Let me turn back to Ms. Jamo. Anything further, ma'am?
No, Your Honor, I don't think it's necessary for the U.S. trustee to get into a back and forth with the Owens about the GoFundMe funds. Our pleadings speak for themselves, and it's not an issue that is going to be resolved here in any event, so we'll just leave it at that.
Okay. Let me ask you this. With respect to a dismissal, is the court's signed minute entry sufficient, or will your office wish to upload a formal order?
Speak to that.
All right, then. I'm prepared to make a ruling. Thank you, everyone. All right. So the matter before the court today is the debtor's motion to dismiss their voluntary Chapter 11 case. The debtors filed this motion, and afterward, the debtors and the United States Trustee's Office have come to an agreement for dismissal of this case with prejudice, and they have agreed to dismiss with prejudice with a bar to refiling this case or any bankruptcy case for a period of 2 years. I've reviewed the motion. I've considered the parties' stipulation, the record in this case, and whatever arguments have been made by the parties. The court does find and conclude that cause exists under the United States Bankruptcy Code, Section 1112B, to dismiss this case. The record does demonstrate that the debtors have been unable to satisfy the obligations imposed under Chapter 11.
I already explained not intentional, and everyone hated me for the math, but it's in the middle.
And everything other than the math, too.
Yeah.
For 11 debtors.
Yes,
And it's also
in
clear
general.
that there's no reasonable likelihood that this case can proceed to a successful reorganization within a reasonable period of time. The court further finds that dismissal, rather than conversion, is in the best interest of the creditors and the estate. I've considered the scope and the nature of assets and the potential for transfers that could be avoided or other claims, and it appears that that would be very difficult and costly for any Chapter 7 trustee to undertake. The remaining question is the scope of any prejudice to refiling. Although the parties have stipulated to a 2-year refiling bar, I believe it's incumbent upon the court to independently determine whether that requested relief is warranted under the Bankruptcy Code and the facts of the case. In particular, since we haven't had an evidentiary hearing. A dismissal with prejudice and a prohibition on refiling constitute extraordinary relief. And generally, the court's rule is that such a bar should extend no further than necessary to address the conduct that has been presented to the court. So again, I do find that cause exists to impose a refiling bar. The record reflects significant failures to comply with the requirements of Chapter 11 and demonstrates that dismissal without prejudice would not adequately protect the integrity of the bankruptcy process. Accordingly, a period during which debtors may not seek relief in bankruptcy is appropriate. The court is also persuaded by the multiple errors, the misstatements, and even possible misrepresentations that the present record does justify a 2-year prohibition on refiling. The court concludes that a 2-year bar will accomplish the purposes of 11 U.S.C. Section 105A and 349A. A 2-year refiling bar adequately protects the bankruptcy process, discourages abusive or premature refilings, and is appropriately tailored to the circumstances of this case. In particular, because the debtors have consented to that 2-year bar, and Ms. Jamo points out an unusual and perhaps novel consideration the court had not previously considered, which is that with more time provided to the mortgage company, perhaps the parties can enter into an agreement or arrangement that meets all the parties' needs with respect to the real property. So for these reasons, the debtor's motion to dismiss is granted. This Chapter 11 case is dismissed under 11 U.S.C. Section 1112B. The dismissal is with prejudice to the filing of any bankruptcy petition by either debtor under any chapter of the Bankruptcy Code for a period of 2 years from the date of the entry of the dismissal order, which shall be the minute entry that will emanate from this hearing. I'm not expecting any additional form of order. Rather, as soon as this minute entry is filed, the case will be dismissed, and that will be the end of the matter. And with that, I believe everything that we were here for today has been considered and concluded. Is there anything else we need to discuss, Mr. Owens and Ms. Naylor?
Nothing.
No, just thank you very much for allowing us to appear via Zoom with the heat
Shut
today.
up.
It's a lot more comfortable for my husband and for me. So thank you.
All right. Well, you're welcome and good luck. Ms. Jamo, anything further, ma'am?
Nothing further from the U.S. trustee. Thank you very much, Your Honor.
All right. With that, then we are adjourned. Thank you, everyone. Good luck.
Thank you.
Thank you.
Yeah, these idiots. And they're still saying, oh, we didn't know it was fraud. And now I can hear an echo. I definitely hear an echo. But
Oh, you do? I thought he said
wait,
it's only one
let's
video.
do this a sec. Go in your mic settings. What is your input for your mic? You know, it has input and output.
My microphone.
What is the output?
The speakers to my thing. You want me to put my headphones into the mic? I can. That
No,
fixed
just-
it last time.
Okay, yeah, try that. Yeah. I know. I have an echo because I'm echoing through Suma.
I didn't have an echo.
Right. I know. Anyway, these morons, I hate that they say, oh, it was hard, it was difficult, I'm sorry, we didn't know what we were doing. It's like for an attorney.
Yeah, you know, they're just too. We're I mean, they're not really playing the elderly card. They're just idiots. They're grifter. They're like shifty.
Well, it's just the whole thing that they think they're smarter than everyone else. I thought you were putting your headphones in.
I did.
Then you have to turn off your speakers.
Oh shit. How come you're so stupid, but it never comes out looking like it?
I don't know. Just...
Maybe because you're not.
Yes, it echoes when I talk because I'm going through Suma. Look, see now that if I mute Suma like this, I have no more echo. See? Now it's back, and she's got her little headphone plugged in and her speakers off. Perfect. All right, thanks everyone for being here. We are now going to proceed to the Lorne portion of the evening, which is going to be much more entertaining. We are starting the Carter Saga. And the Carter Saga really encompasses the entire dynamic of what Lorne does in terms of him making up a false enemy.
I hear you.
Choose the output as your mic. I don't know. Whatever. We'll figure it out. He makes up the enemy based on an assumption he has. Then he yells at Jamie for the way he feels about assuming that's true. And then he goes ahead and just invents this whole scenario that drags out for 6 days. And he tries to break up with her as a threat. But it's good. It starts a little slow, but it's going to be good. The second part of the call. Now we hear the echo again. Oh, now we don't. Now it's good. The second part of the call is essentially him just being on hold forever while Jamie's talking to Carter. So we'll go ahead and switch over there. Thank you everyone for being here. Remember to hit the like button on the way out. And with that said, we will go ahead and do this one. All right. Bye.